been involved with protest politics, whistleblowing, uncovering all sorts of hideous depredations on the part of the establishment for 30 years.
40 years.
38 years.
Now we're just splitting hairs.
And is sort of a one-woman dervish storm of uncovering the slime that lives under the rocks. And she's done this for a long, long time. They go scurrying, some of them fight back and hiss. Some of them have her arrested, some just defame her. I had my go at defaming her. It did work. She wore some headgear which I found to be maybe fashionable, but nevertheless ridiculous. And that was our only argument in the 25 years that we've known each other. Argument of substance, shall we say. But I have such respect for these two women that it's incalculable. Gesundheit. Don't stifle those sneezes. Go on, get after it. Incalculable respect. Both have been involved with what's fondly called left-wing politics for a long time. The politics of the occasional effectuality, where the victories are short, if they exist at all, and sometimes it gathers world attention, such as the anti-nuclear campaign, which is what brought me here to New Zealand to begin with, long time ago. But nevertheless, it takes a lot of perseverance to stay with what you think is right, and to not only stay with it and advocate it, but to put your whole self on the line in the face of defamations, in the face of irrational criticisms, in the face of some hideous things, as we all know these days, are affecting not only, affecting just about everybody, even though we don't know about it. There is an agenda here, as we all know. The agenda is incredibly vicious, this far down the evolution line. Not that I believe in evolution, but presumably we haven't learned very much from all these many hundreds and thousands of years of experience. And if we have, that learning is often crushed right out of us. Oftentimes we are definitely dumbed down. Anywho, back to the local politics scene, because everything really is a hologram, isn't it? You take one little issue and you can blow up the whole thing from that one issue, whether it's water care, whether it's fluoride poisoning, whether it's vaccinating our precious children. The fact is that the politics that these two women have been involved in all of these years can be writ large. Penny is going to talk a little bit about one thing that should have been obvious to people in Occupy movements and left-wing movements and political protest movements, and that is the phenomenon of infiltration and gatekeeping, if you will. Many, many years ago, I discovered, much to my chagrin and amusement, that in New York, and I'll close in a minute, that in New York, where I'm from, back in the 50s, there was a big show trial for these two communists, and one communist who was pilloried and vilified and hauled into court, and turns out that the other communist was an FBI agent, and so was he. Both of these people in the court of law were FBI agents. And the judge dismissed the case as soon as that came out. The fact of the matter is that the protest left-wing conscience movements have been infiltrated since time immemorial. This is, all know about false flags. Well, posing as something other than what you really are is sort of like the ultimate false flag on a micro scale, isn't it? And what we have, and I found again in the 1970s, I believe it was, I had good indications that other organizations like Greenpeace had been infiltrated by the very corporate people that they were protesting against, and made damn sure that Greenpeace confined itself to certain areas of expression, but other areas of expression, such as backing free energy technology, which could, and should have solved all of the pollution problems of the world a long time ago, Greenpeace would never go near it. You gotta, but in New Zealand, here, we're completely culturally oblivious to this very salient, very obvious fact, aren't we? You have an organization. One of the reasons I don't join any organizations, other than the fact that they probably wouldn't have me, is that I'm infiltratable. Our little organization is totally independent of any corporate, any religious, basically any other, organized interest. Even our advertisers, I said, forget about it. If we Catherine and I do another journal called the Journal of New Zealand Journal of Natural Medicine, right? We've turned down. It's a shoestring operation, but somebody wants to advertise and have some influence or get an advertorial, forget about it. Won't happen. The fact is that if you want to walk the path in your integrity, all right, total integrity, you've got to be willing to do it sometimes alone. Because if, not too many people come into organizations who don't have issues. Anywho, can you focus on Penny? I think that's a good lead-in, isn't it? Oh, yes.
That's okay, thank you.
Yeah,
Put my stuff up here.
You want some water?
Oh, no, I'm all good, thank you. Yeah. This is the brainy look. Anyway. Thank you, John. The fact of the matter is that I got involved in politics in 1972 when I was 18, and I helped to set up a branch of the Halter Racist Tours movement at Kurunui College, Greytown, in my 7th form year. I first met Margaret in 1981 during the Springbok tour. I was one of 12 people on the demonstration committee, and we organised all the Auckland demonstrations. In 1981, I was named in the front page of the Herald as a subversive under Muldoon's list. There were 8 subversives and 7 radicals. John Minto was named as a radical. I think John Minto and myself are the only ones out of those 15 people who are still politically active. Although I've not been a member of any political party or left-wing political organisation as such for about 25 years. When I applied for my SIS file a couple of years ago, Warren Tucker, the director, refused to give it to me. So presumably I'm still doing something right. So as far as state forces in New Zealand are concerned, presumably I'm still seen as an enemy of the state. And over this last 2 months, where I have never been subjected to such defamatory crap in all my life, where I have people who are claiming that I am an enemy of the people, well, the question is, which people? And who is it that people who are making these defamatory claims, whose interest are they serving? Before I go into the issue of activists using common sense and applying a bit of due diligence, what I want to quickly do is just set a little bit of background here. I was involved in the Occupy Auckland movement, and from October the 15th last year, I was one of the people that camped at Aotea Square, and although the amount of time I spent camping overnight was limited to a few days at the beginning and the end, I spent hundreds of hours at Occupy Auckland, and arguably one of the most effective things that came out of Occupy Auckland was on the 1st of February this year, where Occupy Auckland General Assembly supported the principle of a draft action plan against white-collar crime, corruption and corporate welfare, which is actually about a 19-point program to help clip the wings of the corporate 1%, who hide behind secrecy, they hide behind a lack of accountability, and when you actually, like myself, have done a bit of research on corruption, you realise that New Zealand's perceived status as the least corrupt country in the world, according to Transparency International's Corruption Perception Index, which is actually based on the subjective opinion of anonymous business people, and you can't actually get the raw data to look at yourselves anyway. But I went to the Transparency International conference in 2010, and I took over 1,000 copies of a leaflet which was entitled New Zealand Corruption Reality Checklist, and at every available opportunity at plenary sessions and workshops, I stood on my hind legs and blew the whistle till my eyeballs bled about how can New Zealand be perceived to be the least corrupt country in the world when we haven't even ratified the UN Convention Against Corruption. Why? Because New Zealand's domestic legislative framework is not yet in place. Our New Zealand MPs do not have an enforceable code of conduct. Neither do our judges. Our judges don't have a register of pecuniary interest. Court proceedings are regularly not recorded. There are billions of dollars at central and local government level where we are not given the devilish detail about where exactly tax monies and ratepayers' monies are being spent. Since Rogernomics, public is bad, private is good, there was a huge amount of contracting out, privatisation of public services that used to be provided in-house at local and central government. And now we are not given the devilish detail of the names of the contractors or consultants, the scope of the contracts, the term of the contracts, or the value of the contracts. The devil is in the detail. We are not given the devilish detail. Also, there are not registers of interest, particularly at local government level, that check for any untoward conflicts of interest between those who give the contracts and those who get the contracts. As far as New Zealand MPs are concerned, there is a register of pecuniary interests, and you may be interested to know that John Key, it is listed in the 2012 Register of Pecuniary Interests, he is a shareholder in the Bank of America. Now, if he was the Prime Minister of Australia, that would be unlawful. In Australia, it is not lawful for ministers to openly own shares in any company. In terms of corrupt practices, we've got corrupt practices in this country that people haven't even heard of. Another one is post-separation employment. There should be a quarantine period from the time people leave public office to taking up a job in the private sector where they can use contacts and influence that they had when they were in public office. It would be unlawful in Australia for Simon Power, the former Minister of Justice and Commerce, to do what he did in New Zealand, which was to go straight through the revolving door from these ministerial positions straight to the chair of Westpac Private Bank, which is actually the New Zealand government's bank that they use. In Australia, that would be unlawful. Here in New Zealand, the revolving door, it's like watching rotisserie chook at central and local government. The number of people that go straight out one door into another is phenomenal. I can give you an example of the former CEO of Auckland City Council, Brian Taylor, who left that position, I think it was in June 2005, and the next month he was on the board of directors for Metro Water. Now the problem here is it's seen as a form of corrupt practice, because are you taking public office in order to set up to feather your nest for when you leave? That is the question. People haven't even heard of this form of corruption. In fact, New Zealand's so corrupt, it's just like normal. That's what people do. Another form of endemic corruption, because you've got two types of corruption. You've got basically like petty corruption, like you give the cop $50 to get off a ticket. We don't seem to have so much of that, although apparently anecdotal evidence is it seems to be increasing. But then you have endemic corruption, which is high-level corruption. Okay, when I went to the Transparency International Conference in 2010, I discovered, to my horror, a type of endemic corruption which is endemic in New Zealand, in my considered opinion, called state capture. What is state capture? State capture is where vested interests, what they do is they get their way at the policy level before the legislation is passed. That is how the Business Roundtable did it. They focused on policy. So what you need to look out for is regulatory impact reports, regulatory impact statements, with whom are the policy analysts that are attached to, whether it's the Ministry of Health, Transport, Housing, whatever, with whom are they consulting? Because what I have discovered is that these policy analysts, what they do, they treat vested interests as if they are independent third parties. So what happens is, then you get proposed legislation which goes via Cabinet, and then you end up with legislation that serves the interest of those vested interests. Now, who's checking at the policy level? Nobody. Why is that? Because neither the Office of the Ombudsman or the Office of the Auditor General, they are prohibited by statute from going anywhere near policy. They are not allowed by law to go there. The only time that the Office of the Auditor General and the Office of the Ombudsman can get involved in matters is once the law is passed, basically is the law being implemented? They've got to wait for the law to be passed. But this getting the legislation that serves these people's interest, that's where we have endemic corruption in this country, in my opinion. And who knows about state capture? Well, myself and my whistleblowing colleague Grace Hayden, who's an ex-police prosecutor actually, what happened was we actually got a meeting with the top guy in the Serious Fraud Office who deals with corruption, Nick Patterson. We asked him what did he know about state capture. He'd never heard of it. I did an Official Information Act request to Simon Power, wanting to know, when he was the Minister of Justice, what were they doing about state capture, and they had no knowledge of state capture either, which is pretty sad when we're the least corrupt country in the world and people haven't even heard of this endemic form of corruption which is just running rampant in New Zealand. So the fact of the matter is that how I got into this anti-corruption stuff was I've been an anti-privatisation campaigner for some years, and what I discovered was that in my research I realised, oh my God, it's not just the water, fighting privatisation of the water, this whole business about contracting, how's it decided who gets the contracts? It's everywhere. And the more you dig, and then I got interested in corruption and finding out more about it, and so people kindly helped me get funded to go to 2 significant anti-corruption conferences, and so I read the material, got the names of experts, did the homework, and then came up with this Yeah, what started as this New Zealand corruption reality checklist, and that then morphed into an action plan against white-collar crime, corruption and corporate welfare, which did end up getting picked up in principle by Occupy Auckland. So with Occupy Auckland, what happened was we ended up getting evicted from RTS Square, and I was a named respondent in the proceedings. And as a named respondent, I defended myself in my own name. And what happened was we got a disgraceful decision from District Court Judge Wilson, which basically the essence of it was that council bylaws, yes, they could trump our lawful rights to peaceful assembly and freedom of expression under the Bill of Rights Act. Well, it just so happens that I know a lot about this issue because I was one of 3 people very involved in the famous Ike Finau signs case. There were 3 of us, Ike Finau, Dilip Rupert and myself. And this happened back in 2002, 2003. And that was the case of someone who lives just down the road from here, Ike Finau, who had signs in his front yard which expressed a political opinion. He was a Water Pressure Group member, Ike Finau, and when Bruce Hucker and Penny Sefa-Weaver sold out on the issue of Metro Water, Ike had signs in his front yard which said dump Metro Water and dump Penny Sefa-Weaver and Bruce Hucker. And we had on there laminated copies of signed pledges that Hucker and Sefa-Weaver had signed before the elections about how they were going to work for the abolition of Metro Water, and unfortunately when they got into power they did the opposite. So anyway, the guts of it was that somebody made a complaint, it went to court. Ike was ordered by Judge Joyce to take down the signs. He got an order of committal for contempt of court and he was facing 21 days jail. And what happened was the signs got changed, and in the end he faced 21 days jail for having 3 signs. One saying GE Free Zone, one sign supporting Team New Zealand because the America's Cup was on, and the third one was a sign that said God Save the Queen. Well, apparently the BBC were keeping a watching brief because was a New Zealand citizen going to go to jail for refusing to take down a sign that said God Save the Queen. I was in charge of publicity. We had this massive national and international sign-on campaign where people would send emails directly to the council saying back off, leave Ike alone, blah, blah. And we also got screen printed a number of signs. Ike was told to take his signs down, so a number of us put signs up. And so what happened in the end was that in 2002, after getting this order of committal for contempt of court, Auckland Council just found it was all too embarrassing, so they slunk back to court with their tail firmly between their legs. Oh, that order of committal for contempt of court, we don't actually want it anymore, and they wanted it removed. Well, of course, the judge can't be seen to be at the whim of any of the parties, and so Judge Joyce, this is the first time in the history of the common law world this has ever happened, apparently, that an order of committal for contempt of court was reversed before the person went to jail. Ike Finau never went to jail. In fact, he never went to court. In fact, I'd go to court with a letter to give to Judge Joyce, which basically challenged his fitness to be on the bench, and Ike Finau was interviewed on radio and he said, oh, Mr. Finau, you're going to court tomorrow? Nah, I've got better things to do, I'm going fishing. And he went, oh my God, you know, this cheeky Islander, you know. And anyway, so what people loved it, hot talkback was hot with it. And what happened was the local government bill was going through Parliament at that time. Well, as a result of the Ike Finau case, what happened was that there was an unholy alliance of Nandor Tanchos from the Greens and Stephen Franks from the ACT Party, and in a most peculiar situation, Parliament voted against the government. Every party in the House, apart from Labour, supported what ended up being Section 1553 of the Local Government Act, that council bylaws could not be inconsistent with the Bill of Rights Act. A huge victory. And we won that on the street. Okay, so I'm very familiar with this. So what happens is that when we have the Occupy Auckland court case, Ross Burns, the Crown prosecutor from the Urewera case, he was the prosecutor on behalf of the council. And so what happens is that the Ike Finau case is brought up and Ross Burns plays the ace, this decision of Judge Joyce. Well, I trump on the top and play the joker. Well, excuse me, this case that you're quoting was not the last word on the subject. In fact, a year later, Judge Joyce reversed his order of committal for contempt of court. So by the time I'm finished, like, Ross Burns is sort of bit slumped over. And the fact of the matter was that this very unusual at district court level for there to be an international legal precedent. So when I actually rang the Wellington Law Library and said, there's actually a later decision. Can you please update your records? And within 24 hours they did that. So anyway, what I'm trying to say, when it comes to this issue of can council bylaws trump our lawful rights to peaceful assembly and freedom of expression under the Bill of Rights Act, I know more than most people because I've been through it. So what happened was that recently we had the appeal in the High Court of Judge Wilson's decision, and because it's seen as a very important test case, what happened was we had an intervener from the Office of the Attorney General. I represented myself as a named appellant. There are absolutely bugger all people there from Occupy Auckland, a number of whom have been getting really stuck into me. When it comes to this important test case, where were they? Basically nowhere to be seen. So what happened was, not only was I able to put in my submissions all this background to the Ike Finau case, to make it very clear from the Hansard record that the intention of Parliament was that council bylaws could not trump the Bill of Rights Act, but I also was able to adduce, fancy word, produce 10 new items of evidence which are political dynamite. Judge Ellis allowed me to adduce all 10 items, although Auckland Council had instructed Ross Burns to oppose the lot. What I was mainly arguing was that the eviction of Occupy Auckland was because it was unlawful discrimination on the grounds of political opinion. That in Auckland Council there were a number of elected councillors who were connected to the National Party, and they had a vested interest in opposing those of us from Occupy Auckland who were fighting during the election campaign the re-election of a National Act government. And the sort of evidence I was able to produce was a new letter that was dated the 11th of November 2011, signed by 8 Auckland councillors to the Auckland Council CEO Doug Mackay, requesting a court order to clear protesters from Aotea Square. Signatories included Cameron Brewer, member of the National Party, Christine Fletcher, who's already been a National Party MP and Cabinet Minister, and George Wood, who was a member of the National Party, and they sort of played the leading role. That date, the 11th of November, might ring a bell for people. It was the same day as the Tea Party tapes. What happened was that a number of us from Occupy Auckland, because I'd been loaned a van, when we found out where the Tea Party was taking place, the meeting between John Key and John Banks, we stormed out of the van with all our banners, made a big fuss, and that same day this letter was signed. Anyway, that letter was previously unavailable because they mucked around about giving a copy. Another piece of dynamite new evidence was that a letter confirming that Auckland Council CEO Doug Mackay is a member of the Committee for Auckland in his capacity as Chief Executive of Auckland Council. Who is the Committee for Auckland? The Committee for Auckland is basically the business roundtable on steroids. What it is an extremely powerful private lobby group which not only includes CEOs of major companies, including accountancy companies, banks, construction companies, but it also includes the CEOs of district health boards, tertiary institutions, corporate charity and corporate Māori. Now, how is it not a major conflict of interest for the CEO of Auckland Council to be a member of this private lobby group? And so, just really quickly, okay, well anyway, there's other key bits of evidence, but what's really important is just an update for you folk. On Friday, I got confirmed from the local government sector manager from the Office of the Auditor General that they have received a copy of an open letter of complaint to the Office of the Auditor General requesting an urgent investigation into the following matters, including the allegedly corrupt conflict of interest of the CEO of Auckland Council, Doug Mackay, who's also a member of the extremely powerful private lobby group, the Committee for Auckland. There's also, I haven't got time to go into it, but with the 7 council-controlled organisations, there are a number of directors and CEOs of these council-controlled organisations who are also members of the Committee for Auckland. Well, the bottom line of all this is that I believe it would be fair to say I've been working my butt off for years trying to expose the 1% who Occupy Auckland are supposed to be opposed to, the 1%. And the bottom line is, like I said, over the last 2 months I've never been subject to such filthy defamatory attacks in my life. I've been blocked from even being able to post comments on the Facebook page of Occupy Auckland, which has over 5,000 members, so I couldn't even let people know about the court case coming up, which I think is absolutely diabolical. The bottom line is this, that I believe that people should always seek truth from facts. You should use your common sense. If you get people who come from nowhere and make a beeline for policy, strategy, or any means of the message or getting the message out, if they act in a sabotaging or obstructive way for no good reason, and particularly if they don't really want to give your name or they use more than one name, ding, 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 ding. And the reason why I say this is that my own father joined the British Army when he was 17 and was in Palestine in 1949. And when he came back and worked at Dunlop's rubber factory, he was approached by the SIS because of his army background and asked whether or not he would spy on the Rubber Workers Union. My father declined. But that taught me, just be aware that if people have an army background, be aware. Like Rob Gilchrist from the Animal Rights Movement, who was outed by his girlfriend as being an SIS informant. He also had an army background. So what happened was that, yeah, there have been people on Occupy Auckland that have been a bit dodgy about giving their names, and to me it's a no-brainer. People should be honest about giving their names, and if you put them into Google, if they've ever done anything of note to the public, that's been useful, something should come up. Now, when you put people's names into Google, and the only things that come up are private companies, ding, 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 especially IT, internet private companies. Well, what happened to me was that I was very active in Aotearoa's Not For Sale, okay? And we voted that, on my suggestion, that for our July the 14th march, what we would do was we would be advocating opposition to the Mixed Ownership Model Act, as it was then, and we would encourage people to see the Mighty River Power investment as socially and fiscally irresponsible, that we would try to encourage people not to buy shares, and what we would try to do is encourage thousands of people to switch off Mercury Energy because it's 100% owned by Mighty River Power, and if the company loses customers, it will lose profits and makes it unattractive. We voted on that in Aotearoa's Not For Sale, and on the 14th of July march, I was one of 3 people who had 2 minutes to push this, and my job was to push the switching off Mercury Energy. So what happened was, to cut a long story short, basically Aotearoa's Not For Sale sort of, yes, with some very undemocratic decision making, what happened was that there was decisions made, not by Aotearoa's Not For Sale, because we were meeting regularly, to basically have a holiday and drop the ball. And the fact of the matter is now is that Aotearoa's Not For Sale isn't really doing anything very much about opposing the sell-off of these state-owned electricity assets. And what happened was on July the 14th, we had this really good leaflet that was encouraging people to join the boycott. And the person who was responsible for Aotearoa's not-for-sale website, an American woman called Linda Ann Wright, was extremely obstructive about putting the leaflet, which was our main organising tool, up on the website that had the name of the group. And I've got a correspondence here, which I haven't got time to go through now, which showed that on a one-to-one basis I tried to encourage Linda to put this information up so we could get on with it. And she wouldn't. So in the end I got so frustrated that I decided, well, I'm going to do a bit of research here, and I got someone to help me, and we found out that Linda Ann Wright had the website www.Aotearoa's Not For Sale, which went through occupiedemocracy.co.nz via Germany and came back to her own private company, Consensus Limited, which has as a stated aim to minimise risk to business. And Linda Ann Wright's very involved in Socialist Aotearoa. Well, I put it to you, that's a bit dodgy, somewhat of a conflict of interest between...
Sorry, but we
Too long?
want to know whether or not there was a result from the court case.
It's reserved. What's happened is, with the Occupy Auckland appeal, we are awaiting the reserved decision of Judge Ellis. We don't know.
Oh, okay.
We don't know. But it's... Yeah, no, that's the thing. We are waiting. We are waiting for that result.
How long have you been waiting?
Well, it was on the 25th of September was the hearing. It was supposed to be down for 2 days, but it only took 1 day.
Right.
Anyway, but, so we're waiting, but if we lose, well, then we'll keep appealing, because this is a hugely important test case, because, you know, what they're trying to say under the bylaw is that you need to get a permit to hand out a leaflet, to march down the street, or to have a protest, and I did the 2-year-old tactic. I basically stamped my foot and said that I've been a protester for, nearly howled actually, for over 40 years, and I had never got a permit to hand out a leaflet, to march or to protest, and I didn't intend to start now, and I would die in a ditch. I would not do it. Anyway, so the judge got that. Anyway, so we are waiting for this reserved decision.
Is the ditch metaphor in court?
Yeah, I did. I said I would die in a ditch.
You said
Yeah, I did. Yeah, I did. And what was interesting was that the intervener from the Office of the Attorney General was actually worse than Ross Burns. Ross Burns, actually, his view, and don't forget Auckland Council paying him some extortionist amount as a Crown Solicitor for Meredith Connell, and he actually believed that the bylaw was not consistent with the Bill of Rights Act because they were requiring a permit.
Yeah, exactly. So how could it possibly?
Anyway, but the point is a very important test case. I mean, you know, I gave it heaps, and and all these people from Occupy Auckland who are busy, having a go. Well, hello, where were they? You know, and
Right. Okay. So the bottom line of all of that is, this seems to me a fairly good example of how to hijack a movement. Yes. Sorry. This seems to be a good example of people. I have to sit next to Pat. All right.
it's all right. I won't bite you.
All right.
I'll try not to.
That's all right. We're on 5 o'clock now.
I'm sorry. Okay.
That's all right. All right. The wrap up that I understand is that this the Linda person was able to get into a position of power in Occupy Auckland, or Aotearoa's Not For Sale, and basically to stonewall the progress of that particular movement. Am I correct?
Well, the thing was that what caused a problem with Occupy Auckland was infighting caused by another person, Suzette Marie Dawson, whose main task seemed to be to really stir up trouble against Chris Edgerton, who was arguably our most effective Occupy Auckland person. I've seen this before.
Without the details, Pat.
Okay, the guts of it is this. People hate infighting. The most dangerous enemy is the enemy inside, who white ant your organisation and make it dysfunctional from the inside. People who spread rumours and tell lies and get people fighting amongst themselves, beware. Don't listen to gossip, seek truth from facts, and just use a bit of common sense, because obviously if you're being effective, the other side will try and stop you being effective, and that is the most effective way they do that, is by making your organisation dysfunctional.
So
but
you don't take the flak unless you're over the target.
exactly right, you don't.
And that, in a sense, that's a very good lesson to fall back on when you are being attacked by people who you thought were on side, and start looking at other motives. But as I said in my short intro to you, this is historical. We should understand what happens and how very, very well organized the 1% is.
Yep.
And how effective they have become at getting what they want, which is the destruction of family, of lives, of wages, of meaning, and make people really suffer. Go ahead.
So it's really important. A major lesson to me from Occupy Auckland was, although it was democracy on steroids because it was 90% consensus decision making, that's great. I mean, I'm a 51% myself, but however, no, that's okay. You have thorough discussions, but if you don't record your decisions, it's like having organisational Alzheimer's, because the next day you meet and you haven't got a clue what you decided the day before, because nobody's taken the bloody minutes. It's just a no-brainer. You record your decisions, because otherwise, without transparency, you can't have accountability, and yeah, it's as simple as that. I mean, it's not complicated. I mean, I know sometimes that people try to use really complicated meeting procedures to frustrate the democratic process, but if you don't record what you've done, but then make copies available of the decisions that you have made. So it's no point just having it on email or on the computer when all these people, homeless people, don't even have a computer. You need to be able to have copies of what you decided in an accessible way, and that's really important. So, so that's it. Yeah.
Well, that's the nuts and bolts of
that's the nuts and bolts
of an awful lot of work. But.
Just the last point there. I mean, the 1%, they hide behind secrecy, a lack of transparency, a lack of openness, and a lack of democratic accountability. If we are trying to set up a society that is opposed to that, we must practice what we preach. We must work in a way that is the opposite to those which we are fighting. And that's why I've been so frustrated with people, anonymous people, making these filthy defamatory attacks on myself with no name, so I can't threaten with them with defamation because they won't put their name to it. I put my name to everything, and then people think, you're egotistical and you're promoting yourself. Well, no, I'm putting my name to stuff. If I had time to write a bloody book and put my name to it, that would be fine. But if I put my name to little things, like articles, somehow that's me being egotistical and promoting myself. Well, that's just bollocks. It's called transparency. And I mean, hello, then people know who's done what. Yeah. But anyway, so, yeah, but just to finish off, in terms of the good stuff that's happening at 30,000 feet, don't you think it's hilarious how New Zealand's perceived to be the least corrupt country in the world, so we should be the most transparent? We're now having legislation where they're looking at having a register of lobbyists so people can find out who's meeting the minister. But what we're finding in Parliament is John Key is saying in a reply to Winston Peters, yes, he had a meeting with Minister Simon Power and Minister Maurice Williamson, but there's no record of the discussion and he can't remember it. So hello. So when the ministers meet the ministers, nobody takes the minutes. Have you ever heard such crap in all your life? I mean, the local cat club keeps minutes, for God's sake. So what's coming out is some really, really good stuff, which shows that New Zealand's status as the perceived least corrupt country in the world has got to be the biggest steaming pile of the proverb you've ever heard.
No, I think New Zealand is the least corrupt country in the world. Because every other country that I've been has been at least as corrupt as this.
Well, over the ditch, like I say, in Australia, they have safeguards we don't have.
You can't offer up Australia as a paragon of virtue.
In terms of some things, I can. Like I'm saying, New Zealand is so full of corruption, people just think it's normal. You get into public office to look after yourself, your mates, and your family.
Come on, man.
Like I said, if John Key was the Prime Minister of Australia, he would be prohibited by law for being a shareholder in the Bank of America. I mean, if you're an insider trader, and I took a private prosecution against John Key, just last point, okay, I took a private prosecution against John Key over Transrail. So all my detractors who are saying that I'm working for the Crown and the police and I'm an enemy of the state, well, how many of them did that? I think I'm the only person who's done that. And and Vinny knows about that, there's a YouTube clip from 2008. But the issue is this: if you, like John Key, have been a foreign exchange advisor for the New York Federal Reserve, if you've been in charge of Merrill Lynch, which helped to set up the derivatives market, which has now caused basically this financial collapse, imagine your opportunities for insider trading if you're the Prime Minister. You're in charge of everything, including the security services, and one must ask how intelligent are our intelligence services when they don't even know the rules that are supposed to govern their behaviour. Yeah, anyway, so there's lots of exciting stuff happening. The thing is, just don't drop the ball, keep on with the job, but what I'm really looking forward to is as many groups and organisations as possible picking up this call for an action plan to prevent corruption, white-collar crime and corporate welfare in New Zealand. Yeah, because that's what this government is really vulnerable on. Thank you. Yeah, exactly right. Yeah. Bit all over the place, but anyway. Shame.